Namaskar, I'm Assistant Professor Kritika Dev from LJ School of Law, and today we'll be dealing with Indian Evidence Act. And under the Indian Evidence Act, we will be dealing with the topic of examination. Yes, when it comes to examination, how the examination is being taken place, and what kind of examination here we are talking about. So, in order to get a clear idea, let's see the section. So here we were talking about the examination of the witnesses. Now, what is the order in which they should be called and what are the other criteria? We'll get to know with the help of these sections. So now let's see section 135 of the Indian Evidence Act, which says order of production and examination of witnesses. The order in which the witnesses are produced and examined shall be regulated by the law and practice for the time being relating to civil and criminal procedure respectively, and in the absence of any such law by the discretion of the court. Now, what this section is trying to say that when it comes to the order of production of the witnesses, like as to how they should be called, what should be the order when it comes to the witnesses, the examination of witnesses, then that shall be regulated by the respective rules of the criminal procedure and the civil procedure. But in case if there is no rule defined by any of these procedures, that is the criminal procedure or the civil procedure, then it is up to the discretion of the court as to such production of witness. Right? Firstly, it should be regulated by the criminal procedure. Secondly, it should be regulated by the civil procedure. And in case when these two are in there, any rules related to these two procedures, or when these procedures do not tell us as to the order of witnesses, then the discretion of the court shall prevail. Okay, now examination of witnesses. Now, what actually is examination and what kinds of examination, that is being mentioned under section 137 of the Indian Evidence Act. Now, it talks about examination in chief, cross-examination and re-examination. Now, what do we understand by examination in chief? Now, examination in chief is the very first examination which is done against a witness. So when it comes to examination chief, it is being done by the party who calls such a witness. First, say if I am, in this case, I am the prosecution and I have submitted the list of witnesses. So when my witnesses will come, I will cross-examine, the examination will be known as examination in chief. And that is the very first examination of the witnesses. So the witnesses who shall be coming from my side, I will be doing the examination in chief of those witnesses, right? So once the examination in chief by the party who actually calls that witness, once it is being done, then it is open for the cross examination. As you can see here, it is open for the cross examination. Now, cross examination shall be done by the adverse party, right? They will be asking the questions in order to get some of the answers which they want that witness to give. So, of course, when it comes to cross-examination, once the cross-examination is being done, the authenticity of the witness is taken as in a very good manner. The witness is actually considered as the authentic witness. Why? Because the cross-examination of the witness is being done by the adverse party. It is a very important stage which should be there, right? And then if at all in the cross examination, as you can see, the questions which have come in the examination chief, on those questions only the cross examination will take place by the adverse party, by the other party. And now if there are some new questions in the cross examination, then with the permission of the court, the re-examination, now again the re-examination is being done by the same party who has done the examination in chief, which means the party who has called the witness. So here the re-examination is being done if there had been any doubt in the cross-examination. Some new questions have come up or there were some doubts in the cross-examination. So in order to get the clarity of those questions, the re-examination is being done by the same party who calls up the very witness. Right? Okay. Now with this, the order of the examination. So when we were discussing it, we even discussed the order. The first is the examination in chief, and there comes the cross examination, and after that there is re-examination. Examination in chief done by the party who calls the witness, cross-examination by the adverse party, re-examination again by the party who calls the witness. Now, Section 139 of Indian Evidence Act says cross-examination of person called to produce a document. Now, what will happen if a person has just come here or been summoned to just produce a document? Now, will that person be cross-examined? What will happen? The section gives us the clarity on this or gives us the clarity when this scenario comes in play. A person summoned to produce a document does not become a witness by the mere fact that he produces it and cannot be cross-examined unless and until he is called as a witness. So here we get a very clear idea that if, for say, I call up a person with a document, now that person has come, first say I'm from the side of the prosecution, I call that very witness in order to submit a document before the honorable court. Now that person just comes and submits that very document. Now that person who has come to submit the document cannot be cross-examined until and unless he's been separately called as a witness, as an individual witness, right? But if he has just come to submit the document, he will not be cross-examined. So that is being said under section 139 of the Indian Evidence Act. Now, leading questions. What do we understand by leading questions? Now, when it comes to the leading questions, what do we understand by it? In simple terms, leading questions are the questions which suggest the answer itself, and the answer is in such a form, or the answer is of such a nature with which the party who's actually putting that leading question expects the witness to give. Now, let me quote an example here in front of you. Were you not present there? Did you see the framing of the leading question? Were you not present there? So the witness will get confused. Should I say yes or no? And it should be framed in such a manner when it comes to the leading question. The answer should be either yes or no, right? So when the leading question is being asked, they're generally being asked in order to provoke the candidate, and it is being asked in such a manner that the witness actually gives such an answer which the person who's putting up the question, or the advocate who's putting up a question, is expecting that witness to give. So it is known as the mind game. Leading questions are generally known as the mind game or the mind questions, right? Now, when they must not be asked. Coming to leading question must not be asked in examination in chief and re-examination. The party who has himself called the witness, they shall not be putting up questions like this in the examination in chief. In examination in chief, the question should be of elaborative nature in order to make the court understand. It should not be in one line yes or no answers. And they're not. Why? Because if they're suggesting the answers themselves to their own witnesses, then how will the court rely upon the witness? So, therefore, when it comes to leading questions, they must not be asked in the examination in chief and the re-examination, which means that leading question should not be asked by the party who calls up the witness, right? Now, when they must be asked, when it comes to leading question must be asked in the cross-examination by the adverse party. So when it comes to the leading questions, they have been asked in the cross-examination by the adverse party. Were you not there, as I mentioned? Were you not present during the incident? Right? So when you put such a question as to just get the yes or get the answer which you like from the witness, that is known as the leading question. Now, section 145 says cross-examination as to previous statements in writing. Now, a witness may be cross-examined as to previous statement made by him in writing or reduced into writing and relevant to matters in question without such writing being shown to him or being proved. But if it is intended to contradict him by the writing, his attention must, before writing can be proved, be called to those parts of it which are to be used for the purpose of contradicting him. So this very simply says that if it comes to any previous statement, of course, if a witness in the same proceeding has stated something, right, then later on that person can be cross-examined on the statements given by him itself. For say, if I state something now, Now later on in a proceeding, then later on I can be cross-examined on the statements which I have given, right? In order to test my veracity, whether the statement I generally give is true or not, or I just simply go to the court and utter whatever I feel like. So, if a witness has given a previous statement, then he can be cross examined on his own statements, right? And if it is something which is in writing, something which I've in any previous statement that I've made in writing, then the question of such writing can be asked from me without showing me what I have written, right? Without showing that you have written that very thing, right, in the diary or in anything that you maintain. Now they will not show it to me, but I'll have to answer. But if it is of such a specific nature as to they are completely telling me line by line that you have written this in this very line, right? Now when they are saying that to me, that time they'll have to show me the writing, that we are talking about this very line that you have written, because they are being very specific. Now my attention is to be brought to that very line in order to cross examine me. Is that very clear? I'm taking general examples in order to make you understand. Okay. So, section 146, which says question lawful in cross examination. Now, what kind of questions are being asked in a cross examination? Firstly, to test his veracity. Now, any question can be asked when it comes to the testing of the veracity of the other party, or to discover who he is and what he is, or what is his position in life. So, general question: what do you do? Where do you stay? What is your living standard? How much do you spend? Anything like that, in order to actually get where he, though when it comes to the leading questions, when it has actually no connection with the direct proceeding. They have just been put in order to actually get the answers from the witnesses. So in the cross examination, you can even ask such questions, and to shake his credit by injuring his character, right? You can ask even such questions which may shake his credit. So once the person is being provoked, the person is tend to speak the truth. You must have seen it that once a person is generally being provoked, that person is tend to speak the truth. So these are the kind of questions which can be asked in the cross-examination. So here we are clear with the concept of examination in chief, cross-examination, re-examination. What kind of questions can be asked in the cross-examination? What are the leading questions? And every provision related to it. So thank you for listening, and keep studying, keep revising. Thank you so much.